okay with you, Mark, and Tom, we can get started at this point. I think we have a sizable number of attendees, and no doubt the number will continue to grow as we go forward. But with your permission, I think we can get started.
Please.
Okay, terrific. So good evening, everyone, and welcome to From John Jay to John Roberts, the Law of Nations in U.S. Courts, a webinar organized by the Washington Foreign Law Society. I am Michael Teodori, Chair of Programs here at the Washington Foreign Law Society, filling in for our one and only Giuliana Cane, President of the Society. The Society was founded in 1952 to promote knowledge of international legal matters, comparative legal issues, and foreign law. A couple of housekeeping notes before I introduce our distinguished panelists. Participants will be muted during the webinar, but you will be able to communicate with us via the Q&A section. So please send any questions to our panelists using the Q&A feature on your screen. We will get to the questions at the end of the session. As a reminder to everyone, the session will be recorded. So prior recordings of all WFLS events are available on our website. And finally, don't forget to follow us on Twitter. Our handle is @WFLS1952. I'll repeat that one more time, @WFLS1952, and LinkedIn. So let me now introduce our distinguished panelists. We have Mark Feldman. Mark has practiced law for 6 decades, including 16 years at the State Department, where he was deputy and often acting legal advisor. He teaches foreign relations law at Georgetown. Among other accomplishments, Mark has played a major role in drafting the Foreign Sovereign Immunities Act and the Iran Claims Agreement. Thomas Lee is the Leitner Family Professor of International Law at Fordham Law School. He's also of counsel at Hughes, Hubbard, and Reed, adjunct professor at NYU School of Law, and a member of the ICSID panel of conciliators. He has written extensively on international law, U.S. foreign relations law, constitutional law, federal courts, and legal history. Viewers should be aware that today's program follows our May 12th program on international human rights in the Supreme Court, which is available on our website and YouTube channel. Mark and Thomas will be debating the court's decision in the recent Nestle v. Doe case, in which it held that the Alien Tort Statute does not support claims against U.S. corporations based on child slavery in foreign lands. They will each have 2 10-minute segments to present their view of the case in light of the court's broader jurisprudence on the role of international law in the domestic U.S. legal order. With their permission, I'll be keeping track of time to make sure that we have some time left over at the end for questions from the audience. One final note before I leave the floor to our panelists, please consider becoming a member of the Society. There's a discounted rate for students and government employees, and I'll be putting the link on the chat on your screen. With that said, Mark, feel free to take it away.
Well, I want to welcome Tom Lee to our platform, and he's agreed to kick off this discussion. And there's no one who knows more about the origins of the ATS and the status of international law in the 18th century as regards the U.S. Legal system. So, Tom, welcome, and please begin.
Thank you, Mark, and thank you, Michael, and the Society for this opportunity. As Michael had mentioned, the origin of this particular panel was the panel that we had done in May, which was much more about sort of evaluating predictions on a couple of very important foreign relations law decisions, one involving foreign sovereign immunity, the other involving the Alien Tort Statute. And then Mark had the idea to sort of do a follow-up panel that talks a little bit, uses those as a springboard, but talks about some of the history of the law of nations and customary international law in the United States, and how the Alien Tort Statute came to be in the US Code, and what's happened over time. So that's where I'm going to begin. And then we're going to exchange in 10-minute increments and then open the floor to questions. So Nestle Cargill, we discussed the case at length at the May panel, and I think most of you are probably aware that the Alien Tort Statute, the Supreme Court issued a decision that preserved the possibility of U.S. corporate liability, but essentially kept it extremely narrow. Basically, the allegations of child labor with respect to U.S. corporations involved in the cocoa industry abroad did not suffice to defeat the presumption of extraterritoriality. Justice Thomas wrote an opinion for the court, and in part 3 of that opinion, he sort of made it pretty clear that his belief is that the only circumstances in which you could have liability under the Alien Tort Statute might be one of the historical paradigms that the Supreme Court had talked about with regards to the Alien Tort Statute, those being piracy, violation of ambassadorial privileges, and something called a violation of safe conducts. And so what we've seen is a dramatic sort of diminution of the role of the Alien Tort Statute from the Filartiga decision in 1980. The Supreme Court didn't have any alien tort decisions until Souza versus Alvarez Machain in 2004. Justice Souter for the court had sort of given a narrowing construction, but basically preserved the idea of Filartiga. And then in the span of the next 17 years, you saw Kyle, which said that basically you apply the presumption against extraterritoriality with regards to Alien Tort Statute actions. And then Jesner, foreign corporations are not liable under Alien Tort Statute. And finally, Nestle versus Cargill does not say that US corporations are not potential defendants under the Alien Tort Statute, but leaves a very thin slice of possibility there, and really applies the presumption against extraterritoriality in a very robust way. I want to begin by saying my own scholarship. I've been studying the law of nations now for, it's hard to believe, 20 years. And I first came to the topic because of the Alien Tort Statute. As a summer associate at a law firm called Mungertals and Olson, I worked for 2 lawyers, Kristen Miles and Dan Collins, who's now on the Ninth Circuit in the Unical cases. And I remember thinking, what the heck is this thing? Therefore, launched a lifelong interest into this particular statute. And my scholarship essentially says it wasn't a human rights statute, it was a national security statute, is my basic thesis. The idea being that the statute was about affording the possibility of money damages in US federal courts for aliens who suffered an injury to their persons or property under circumstances in which the United States might be held liable as a sovereign. And this was because the United States was militarily weak, wanted to resume trade with the European powers, particularly the British, and they wanted to provide a mechanism for redress of injuries. The general point I'll make, so that's sort of how the origin story of the Alien Tort Statute came to be. The general point I want to make is, and here I think Mark and I would agree, how important the law of nations was to the early United States, right? The United States was a nation dedicated to the rule of law. This is sort of debated among legal scholars, but they were definitely committed to natural law. And the most famous book that the Americans used by Vattel was called the Law of Nature as Applied to the Conduct of Nations. And so the idea was that just as the law of nature applied to human beings, the law of nations was the law of nature as applied to the conduct of nations. And so they had that way of thinking about it. And from a pragmatic perspective, it was a way for the United States to signal that they were a law-abiding country. I mean, they had just committed a war of revolution. And it's very interesting if you look at customary international law at the time, whether or not the theory of revolution was consistent with law of nations, because the prevalent rule was that the mother country had to let you go before you could become an independent nation. And this is what the Declaration of Independence is about. Richard Armitage has written about this. But the British, interestingly, when it was the Dutch seeking to liberate themselves from Spain, of course, took the view that sort of more of a practical view of what constitutes an independent nation. Then, of course, when they're in the other position, they took a very a different kind of view. And so the United States was very much committed to the law of nations. And from a jurisprudential perspective, the US cupboard was bare. right? We did not have a lot of homegrown norms. We borrowed from the English tradition, the Anglo-American common law tradition, but there were problematic reasons why some of those norms were problematic. And so the United States was very much, because they wanted to be accepted in the community nations, because they were a law-abiding nation, because they were committed to natural law, and because they wanted to take the rules from somewhere. They borrowed heavily from the law of nations. We're in a very different place now, and I think that really the large debates are about translation, and the Alien Tort Statute had been this very interesting vehicle through which the human rights movement could engage in public litigation in the U.S. federal courts, and it seems pretty clear that that door has been closing, and the Supreme Court isn't particularly interested in having that door open. And in that sense, it's very much of the same cloth as what's been going on with Bivens jurisprudence, what's been going on with 1983, what's been going on with implied rights of action from statutes that aren't explicit about these things. Basically, it's a part of the piece of that. So anyways, that's all I sort of had to say, give you some perspective of where this statute came from and the US historical commitment to the law of nations. I tend to be more of a realist about why there was definitely a rule of law component, but again, the US was a militarily weak state. They benefited from being known as law abiding, and they wanted to redress injuries with respect to the aliens, foreigners from more powerful states, so that they could give opportunities to avoid war and to resume trade and diplomacy. So that's sort of my account of the origins of the Alien Tort Statute. Michael, is that 10 minutes? Am I on the nose to hand it over to Mark?
You're shy of that, but I think it's a good time to shift it over to Mark.
Okay, so I pass the baton to you, Mark.
Well, my purpose here is to be provocative enough to get Tom back into because he has a great deal more to say. And to all who are listening who want to pursue this subject, and some of you know it quite well, I recommend Tom's Georgetown Law Review article, which lays out how the framers looked at the law of nations. And I won't take the time to say it, but Tom may have a chance to revert to it. I want to say this, that when I was practicing law in the State Department and in the decades immediately following this, I was practicing in the 60s, the 70s, the very early 80s, and then I went to private practice, and I'm still doing some of that. There was a uniform view from the left to the right that customary international law was an important part of US law. Louis Henkin, who was probably the dean of the scholars of international law and the primary reporter for Restatement Third, approached this from a progressive development of law, human rights point of view. Monroe Lee, who was my boss as the legal advisor and one of the promoters of the Foreign Sovereign Immunities Act, and then happened to be in the chair as legal advisor when that statute was finally enacted in 1976. He represented the corporate world, and the Rule of Law Committee, which was responsible, among other things, for the Second Hickenlooper Amendment, the Sabatino Amendment, was pressing very, very hard for judicial development of international law, primarily for the benefit, for the protection of American investors abroad in the context of security for international investment and international development, to try to get away from the cycle of incentives for investment, expropriation, coercive diplomacy, and so on. And the United States, back in those days, when I was litigating the Kalamazoo spice expropriation cases against Ethiopia, we had the full support of the State Department and the US government behind us. And David Stewart will remember all of that very well. Today, I think it would be hard to get the State Department support for bringing a cause of action under an FCN treaty, because I think in somewhere along the line, perhaps in the aftermath of NAFTA, the United States government decided that it didn't want to be sued as a defendant, and in any kind of cases, really. And the Justice Department for many years now has taken a very protective view, which has caused them, and there are other ideological reasons, as our legal society, like our political society, has become more conservative over the years. The climate today in which the cases are being decided is dramatically different, due in part to the rise of the Federalist Society, the Reagan Revolution and all that followed it in terms of, and Scalia's, my classmate at Harvard, Nino Scalia's impact on jurisprudence. All of this has moved the discourse far to the right. And one of the principles is the emphasis on national sovereignty and a limitation of global commitments and international influence on law and policy, to the point where I remember being shocked a few years ago when I was teaching with David Stewart, was teaching foreign relations law at Georgetown, to read a piece, I think it was a book actually, by Jack Goldsmith and Eric Bosner, in which they argued that in the policy process in the United States government, compliance with or international law should not even be noted as a US national interest. Let's turn to the cases and what's at stake here in following the Nestle opinion. Justice Thomas's opinion had the support of 8 justices. Alito dissented because he wanted a different issue to be addressed. He wanted the issue of corporate responsibility to be addressed, and the rest of the subtle and complicated and fateful issues to be remanded. So he wasn't happy to sign off. I can't begin to, I don't have a lot of, my views are not like Justice Alito's. I'm sure there are people in this audience who can explain better than I could what he's getting at here. But what's important, I think, for purposes of one of our attendees has asked the fundamental question: is there any future for the ATS following this opinion? And Tom has given his, I think, carefully considered view that it's very limited. I don't dissent from that, but the prospects for a dramatic change in the legal principles that have been established by prior Supreme Court cases is inherent in or inheres in Part 3 of Thomas's opinion. And there he's arguing a view that is put up by many scholars associated with the Federalist Society's point of view, that you can't have that in order to have a cause of action, the courts cannot rely on customary international law. Justice Thomas equates that, and many other members of the court do, with judge-made law, not recognizing that the framers understood customary international law to provide rules of decision for US courts. And on this point, I just want to give you a little more detail on the history. And the whole burden of my presentation here is to say that the case that is being made on grounds of an originalist interpretation of the Constitution is false, totally false, and is either hypocritical or deliberately distortion. There is no doubt that, in my mind, that the framers understood when they adopted the ATS that there was jurisdiction, that was a jurisdictional statute, and that the rules of law that were to be applied there were to be found in customary international law. And to give you a couple of proofs, and there's a risk, Mike, as always, that I'll go over the time. You can catch me, but let me just make a few points. The Federalist Papers make clear that uniformity in interpretation of customary international law, and particularly U.S. obligations under the law of nations, as Tom makes clear in his article, included both conventional law and custom-based law, as well as natural law, general principles of law adopted by so-called civilized nations. And the Federalist Papers make clear that not only was the aim of uniform interpretation of those obligations, because this was a national security statute, there could be severe consequences in international relations if states or individuals would violate U.S. obligations under international law, then called the law of nations. So the purpose of the Constitution itself, and more particularly the federal judiciary, one of its prime purposes was to ensure uniformity and compliance with offenses, with the rule of established by international law. To that effect, John Jay's proofs of that. John Jay was the Secretary of State during the Articles of Confederation. He was the first Chief Justice of the United States, and his charge to the jury following George Washington's neutrality proclamation in 1793 affirmed the right of the government to prosecute people for violations of the rules of neutrality under customary international law, even without a statute. That was reversed. Not reversed, but the Supreme Court in 1815. I mean, a good number of years later, decided that there was no such thing as a federal common law of crimes. The Congress did have to enact a statute, and that was a civil liberties interest, really. But it was not a rejection of international law, and there were no legal precedents cited for that. It's striking that the Supreme Court in that case said that this conclusion was really based on the public opinion, the consensus of the American people following the Napoleonic Wars and the Neutrality Proclamation.
Mark, I think that's a good note to pass it back on to Tom.
Sorry, so I'm going to do I agree with 75% of what Mark just said, right? I have a slightly different view of how the ATS has a connection to the law of nations. So it says, the ATS says a tort only in violation of the law of nations or a treaty of the United States, right? And so my view is that the cause of action is torts, which in the Blackstonian sense is a non-contract injury to person or property. And in violation of law of nations or a treaty in the United States doesn't necessarily signal like a substantive norm, like a human rights treaty. It just identifies who is a friendly or an enemy alien. So for example, the US signed a treaty with Prussia in 1785 that said that, even though when two countries are at war, you are allowed to inflict injury on another person or property, we will reserve certain categories of enemy aliens to be not susceptible to injury. So had there been a war between the United States and Prussia, even though generally you can harm enemy aliens, if you were within the protected category, you could actually have sued under ATS. So on my view, it's the tort that's the cause of action in law of nations, in violation of the law of nations, or in violation of a treaty of the United States. It just identifies which aliens can sue, right? Because there was this foundational distinction between enemy, friendly, and neutral aliens, and friendly and neutral aliens could sue. Now, I'm not sure Justice Thomas realizes this because he doesn't seem to have read this part of my article in the Columbia Law Review, but the safe conduct violation under Blackstone and Vattel, and this is absolutely clear, what that meant was if you were a friendly or a neutral foreigner and you were in the United States owed you a duty of safety. It's just kind of like the duty in a US passport today. And so if you were injured, then that was a violation of the law of nations, right? So if we were going to be truly originalist about the ATS, then a Chinese national who gets injured in a Walmart parking lot, right? That would be actionable as a safe conduct violation under ATS, right? I mean, I don't know if these suits are being out there, but in a way, what was sort of beyond contemplation in the law at the time of the age of sail happens on a routine basis now. And so to some extent, the originalism expands the aperture of what would be actionable under the ATS, right? So that's just a clarification. As a more general matter, and this is a clarification too, because Mark had asked me, does the United States care about customary international law anymore? What has changed? And I want to make a distinction between what is happening in courts and the United States executive branch, for example, right? I just did a duty as special counsel to the Pentagon, and the DoD cares about customary international law all the time, right? The Navy, the 12 nautical mile limit. I mean, that is to the United States, because we have not signed the treaty, a rule of customary international law that the United States applies, believes in very firmly all the time, right? And so there are a number of areas where the United States believes very firmly in customary international law. It's just the question of how it gets cashed out in courts. And that has become much, much more sensitive. But even there are certain pockets that are, I would say, not as controversial. For example, the law of admiralty, right? Collisions, shipwrecks. What happens if a seaman gets injured and you pick up somebody on the waters, and then what are you supposed to do to them or whatever? I mean, all this law, that was customary international law. And the cases, Jensen, all these old cases are still law. The admiralty law still constitutes an area in which the US federal courts can pluck rules from the law of nations and use them as rule of decisions. It very rarely happens because we have all kinds of statutes in that space now. And the United States has, the federal courts, including the Supreme Court, have had so many admiralty law decisions that they don't actually have to go to the cupboard of the law of nations directly and pull a rule anymore, because there are so many US Supreme Court decisions, so many statutes. It doesn't happen frequently, but they could. Now, there are some people who believe that power should be diminished, but it's still there, right? So what's happened, and I think that Mark is right, the Federalist Society is a part of it. And I think really, I mean, I actually identify the Alien Tort Statute as what really set off all of this, right? But there has been a Thermidorian reaction against customary international law use in the federal courts, and he's absolutely right. You look back at a case like Sabatino, customary international law was sort of a way for US corporations to propose a means of getting around the expropriation puzzle and saying, well, we're actually entitled to compensation under customary international law. The ideological valence has shifted, and now customary international law in federal courts has become a very different kind of issue. But I think the United States is still committed to customary international law outside of the courts in various theaters. And we can debate the extent to which, for example, I think Mark might say, of course, the United States Pentagon does purport to engage in, law of war analysis, proportionality, these customary international law rules when they do legal analysis or legal approvals of authorities for military operations. But have they ever said no? I mean, have they ever applied these tests in a way that is highly restrictive. And he's probably right to say no, but what country does, right? I mean, what country with the power generally, when the British were the paramount maritime power, I mean, they cheated all the time on the rules of price. And it used to drive the Americans crazy because they say, like, look, your judges are moving the chains constantly, right? So it's been an artifact of the nature of the jurisprudential nature of customary international law. But to some extent, we still do that, but it has become really a fraught issue in the courts. And I identified the Alien Tort Statutes Philartica incarnation as sort of the lightning rod for it all. Is that enough? Is that enough pyrotechnics for our debate here, Mark? And to tell us forward?
I'd like to join the issue. I happen to agree with you that the Philartica was. I think I understand why my colleagues in the Carter administration went the way they did, but I had concerns about it at the time, based principally on the issue of reciprocity. And I'd like to continue a bit because I think what's at stake in this, I don't think this debate is resolved. The question is how many people agree with Justice Thomas's part 3, and I count 4, and those 4 from what they said in this case and what they have written elsewhere, Thomas, Gorsuch, Kavanaugh, definitely, I assume Alito. And what I don't know is Roberts and Barrett. And the reason why this counts, because if in fact the point of view that there has to be a statute to create a cause of action under the ATS or otherwise, and that CIL can never be a cause of action because it's judge-made, that will mean that there is no such thing as the common law, federal common law of foreign relations. It will reverse Sabatino. It will reverse Sosa. And my concern about that, I can see the changing circumstances in the world, why those decisions might be justified. But the idea of putting this on the ground, that this is consistent with the constitutional text and original intent, annoys me to the core. And I just wonder if you give me a couple of minutes to make these points further. The primary argument, and it's made, I've been using the Bradley Goldsmith case book in foreign relations law for years now, and the primary argument that they make, and that Scalia made in his dissent in Sosa, are 2. One, that the grant to Congress of the power to define offenses under the law of nations, that grant of power in Article 1 means that there cannot be any action by the United States government absent congressional action. As I said, the neutrality proclamation and the surrounding debates, John Jay's charge, the debate between Hamilton defending that and Madison attacking it, make absolutely clear that none of the framers had that viewpoint. Madison, who together with Thomas Jefferson, strongly opposed the neutrality proclamation, both on constitutional grounds, separation of powers grounds, and foreign policy grounds, claiming it to be a violation of our treaty with France. He did not even make the argument that judges could not apply customary international law. And in fact, the cabinet had had tried to pass the buck on the neutrality conflicts during the Napoleonic Wars to the Supreme Court, when Thomas Jefferson wrote John Jay, who was Chief Justice, to ask for advisory opinions. And he declined to do it because those cases were going to come before the court. And to credit Tom Lee, his article, the Georgetown article in particular, makes a passionate case for the framers' intent that the courts be an active force, particularly the Supreme Court, in the nations of compliance with international law and in our foreign policy generally. The other argument that is made, and it's made particularly by Scalia in his dissent in Sosa, is that no matter what the framers might have been thinking about the causes of action, Erie versus Tompkins changes everything. And there is no such thing as federal common law in a case arising under diversity jurisdiction. And Sabatino flatly held otherwise. And Kavanaugh, it just annoys me because he's so brilliant, who's written some of the most powerful opinion pieces in his opinions on the limitations of international law in the U.S. courts. Doesn't even in some of those cases arising out of the War of Terror, doesn't even mention Sabatino. I would like to also take a minute to criticize the Phillips case. Can I have a couple of minutes on that?
You've both been parsimonious with your time, so you have about 7 or 8 minutes before we head to Q&A.
All right. Well, the two cases have to be seen together. The compelling interest of the Supreme Court, and Phillips was a unanimous decision holding that the Foreign Sovereign Immunities Act, in particular the expropriation exception, refers to violations of the international law of expropriation and thereby incorporates the domestic takings rule. And that bars the litigation in the United States courts of any taking associated or taking of a national's property in the course of a genocide or other human rights doctrine. The powerful prudential considerations here involve international order considerations. Is it appropriate for United States courts or to be deciding cases involving disputes between a foreign country and its own citizens when there is no connection with the territory of the United States? It's a perfectly legitimate concern, both on grounds of reciprocity. The United States is at risk around the world as one of the major actors and for war crimes and all kinds of issues, slavery, segregation. I mean, there's any number of atrocities in our history. And I understand that impulse, and I wasn't surprised by the decision. But the opinion is an absolute disaster. It makes mistake after mistake. And I'll just give you a few. First of all, it pretends to be based on the text of the statute, which is just absolutely fiction, because what it's doing is adding some absent language. The expropriation exception talks about takings in violation of international law. That's number one. Secondly, it states that Congress had a historically different view of what it states in some form of words that I don't have in front of me. Basically, that Congress would have understood the law the way the court is deciding it, and in fact, the issue was brought up before Congress in the 1973 hearings. There was a concern on the part of some congressmen and on the part of the State Department that the retroactive application of this statute, and we had not addressed that in the text, would bring to bear, would expose, bring to the US courts some very difficult foreign cases, and not just Holocaust cases. I was, among others, decided not to address that, not to try to cure that, because we didn't think we could get the statute passed. That's the history of that. Another mistake that they make is to state that the Foreign Sovereign Immunities Act is to be applied in the light of international law as it existed in 1976. We never had any such idea, and that is inconsistent with the Supreme Court's decision in Sosa, which is forward-looking. And its decision in JAM as well. We were the first country to codify the law of foreign state immunity in a statute. And we understood the international law was rudimentary. It had some basic points. Now, another mistake, even more egregious, it's called out by Bill Dodge in one of his articles, is the assertion that the International Court of Justice and international law generally preserves foreign state immunity in cases of human rights violations. Just a blanket statement to that effect. We don't have time to go into all the reasons why that.
Mark, why don't we give Tom a couple minutes for a last rebuttal before Q&A, because we have a bunch of questions which we're not going to be able to address all of them, unfortunately.
Yeah, so I see in the chat, Mr. Bettauer, and then in the questions that were submitted in advance, there were questions about Charming Betsy and the fact that even as a matter of interpretation, the Supreme Court and the courts seem much more hostile to using customary international law. I think that's right. In fact, David Stewart and I both contributed chapters to a book by Paul Stephen and Sarah Cleveland, who were the editors, about the fourth restatement. And my chapter was about the fact that between the third and the fourth restatement, all of these instances in which customary international law was used as an interpretive aid are sort of washed out in the fourth restatement, right? Case in point, Justice Scalia's own opinion in the Hartford Fire case sort of talks about, yeah, there's a two-step to the presumption against extraterritoriality. The backstop is what customary international law has to say about how far prescriptive jurisdiction will go, right? And he would never have written that in the 2000s and the 10s. And so in some sense, there has been this shift away from using customary international law as a friendly amendment or some kind of thing that's part of our historical toolbox. And again, I sort of think that it has a lot to do with the Alien Tort Statute and the fact that the United States, but as an originalist matter, there I agree with Mark. I mean, if you're an originalist, it's very hard to disagree with sort of an institutional profile of the federal courts to be active and engaging in customary international law. And two, it's wrong to say that they had sort of a static, backward-looking view of how that engagement should go on, right? Now, if you're not an originalist, that's all phooey and you don't have to care about it. But if you're an originalist, you should care about these things, right? Because that's sort of part of what you find in it. The one amendment I'd have to add to what Mark said, Souza, Mark said it's sort of forward-looking, and Souza, sort of a disclaimer. I clerk for Justice Souter, so you can take my words with a grain of salt here. Souter is forward-looking, but it's also backward-looking, right? I mean, the test that Souter articulates in that opinion for ATS cases is it has to, yes, there is some movement, but you're looking for norms that are specific, universal, and obligatory to the same extent that the paradigm violations of piracy, ambassadorial infringements, and safe conducts were at the time the ATS was enacted by the first Congress. And so, yes, he does create room for forward-looking dynamism, but it's also a profoundly backward-looking test that he articulates, right? And so in a way, that's kind of like Justice Souter's jurisprudential philosophy in a nutshell, right? But I do agree with Mark wholeheartedly that they intended a very energetic, dynamic role for the federal courts in foreign affairs. I mean, obviously, the Supreme Court and the federal courts today are not that institution. I mean, we haven't had a Secretary of State as Chief Justice in a very long time since, I've been off counsel with Hughes, Hubbard, and Reed for a while, but basically since Charles Evans Hughes, right? Which is a long time. And so the federal courts are very different. And so the institutional profile doesn't match. But if you're an originalist, you shouldn't care that much about these things. So I agree that Mark is correct in sort of pointing out this this tension, this inconsistency. One might even call it hypocrisy in those kinds of positions.
I think that's a great point to start to address some of the questions we got from our audience. Let me start from one question we received from our attendees, and I guess Mark can start, and then Tom, you can chime in. To what extent do the courts today apply John Marshall's canon in the Charm and Betsy case that statutes should not be construed to violate international law, if there is any other possible construction?
Well, I want to thank Larry Walters, who's listening, for raising that question. And my answer, I begin with the notion that we rarely talk about it. We mention it as a given, as part of the history. But in our foreign relations course, I didn't even assign those cases. And I had forgotten to put it in the list of cases that we circulated. And that's an embarrassment because it certainly belongs there. And the answer is that it is, I don't think it's really a rule of decision anymore. It is mentioned occasionally. I found 2 Ninth Circuit cases that touch on it. And in the first one, which involved indefinite detention by INS, Reno versus Ma, back in 2000, it was the 4th reason for the decision. So the point is that we know that the courts today will write opinions to reach results, even when those opinions are implausible. They'd rather reach the correct result, even though they deny that they're result-oriented. And that applies on the right as well as on the left. So you'll see this cited. I want to quote what the 4th restatement says about it. And by the way, the canon, as stated, it is very emphatic whenever possible. The court should construe a congressional statute so that it conforms with international law. The 4th restatement says, where fairly possible, to avoid conflict with international governing jurisdiction to prescribe. I think the observations of the scholars, I'm thinking of the notes that the Bradley Goldsmith book, emphasize correctly that a lot of these concerns have merged into the doctrines of, found expression in the doctrines of comity. On the one hand, international comity, and 2, judicial deference to the executive. And there is some language in another Ninth Circuit case dating from 2010, Sarah versus Lappin, which involved prison pay, a human rights claim, which basically says that this principle, this canon, only applies where conformity conformity to the law of nations is relevant to international comity, and it makes clear they mean that when could be a foreign relations problem arising out of non-compliance. So I think the doctrine is still out there. It's perfectly appropriate to cite it. It's not going to carry the weight that John Marshall intended for it.
So Michael, I could, there's a couple of questions in the queue, and I can address those.
Please do.
Yeah, James Michelle, doesn't the demonstrated judicial hostility to jurisdiction based on customary international law imply similar hostility to reliance on any notion of federal common law? I think that's right. I mean, I think that basically, with one qualification, I think that we live in an age of statutory interpretation and the Supreme Court profound suspicion about federal common law. And so it used to be judges would have these multi-factor tests, and even if you had a plausible statutory interpretation out there, you'd actually go to the multi-factor test and get to the result that way. That's not the world that we live in now. It's very interesting is the one qualification to to my answer to Mr. Michel's question is there are certain federal common law doctrines of passivity, right? Abstention doctrines, state sovereign immunity. And in that area, it seems to me, basically there's still a lot of enthusiasm for federal common law in with respect to doctrines of passivity as opposed to cause of action creative doctrines, right? So federal common law doesn't necessarily just have to deal with active cause of action type doctrines. There are also passive doctrines, and I think that the passive doctrines are fine. Do we ever foresee the United States Senate ratifying the Rome Statute? I can answer that question very quickly. No. 2/3 is a pretty high bar. I think even the Biden administration seems to be pretty allergic to new governance institutions, international governance institutions. So I just don't see that happening in our lifetimes.
Why don't we also address a comment I saw in the chat on the Supreme Court's practice on the interpretation of treaties. Ronald Batower from the chat notices that U.S. courts tend to rely a lot more on U.S. statutory law over customary international law, and that often gives results that diverge in terms of the interpretation of the norms with those of other countries. Mark, do you see this as a problem?
Well, it depends on the context. It can be a problem, but it's a long-standing divergence in the jurisprudential approach. It reminds me of the differences on self-executing treaties, where countries may or may not understand our dual system and what's implied when you make a treaty commitment and it's not the law of the land. I want to revert, and I think this is relevant to what Ron is concerned about. The abiding lesson that students, particularly foreign students, need to take away from this history is that whereas one of the primary purposes of the framers agreeing on a constitution in the first place was to enable the federal government to ensure compliance with international obligations of the United States. We have not succeeded in that. And I'm thinking particularly about the death penalty cases and all the litigation around implementation of ICJ orders and so on. The more worries, I have a little bit of a dissent from Tom's emphasis on the Pentagon's attachment to the law of war. It's true, of course. I mean, the JAGs are, the principal custodians of the law of war, but the policymakers are not in the Pentagon, and the issues that we had in the war on terror about torture and so forth. I mean, everybody in this audience knows that Abu Ghraib was not just a disgrace to the national honor, but it was a serious compromise of our war aims. And the practices of the Bush administration in respect of compliance with international law norms, humanitarian law, and so on, I think particularly as when you think back to Justice Kennedy's reaction, are responsible for a good many decisions in the Supreme Court where the court intervened in matters that you would have thought in normal circumstances they would have deferred to the commander-in-chief during an act of hostilities authorized by Congress.
Why don't we circle back to the beginning of the program with a final question? Unfortunately, there's no more time for other questions. going back to the decision that spurred this program, Nestle v. Doe, does it put a death knell on the ATS? And Mark, I know you addressed this briefly during one of your segments, so let's have Tom start here briefly, and then we can go back to Mark for the last word.
Well, I give you one possibility, right? I mean, if you're going to be originalist and you believe that my theory of the safe conduct, then basically you're gonna find foreign victims of muggings and various kinds of injuries in the United States. Go look for an originalist judge, and you might actually have a ball game there, because in some sense, as long as the foreigner is from a national with whom we are not at war, which is pretty much everyone except, I mean, the Chinese certainly, right? So the other possibility, I think, is there are these cases involving ATS claims against U.S. corporations who are government contractors or officials that don't get coverage under the FTCA, that might be corporations and so forth. So you could imagine a situation in which you could, and this is being litigated in the courts. There's a theory called derivative sovereign immunity that some of these government contractors are proposing, because there's a case called Boyle, a 1988 case, which the law firm I'm affiliated had litigated, that sort of introduces a government contractor defense, but the lower courts have confined it to products liability. So there's a number of situations where they involve like contractors and services and things other than products liability. And so you can imagine a situation in which you could sue U.S. corporations involved in contracting that don't get the coverage that they want. So maybe you could do that. One thing that Breyer had sort of thrown up there in Jesner and was sort of out there is, well, what if the U.S. gives refuge to somebody that you can imagine a renegade corporation or something like that? Could that work? And I think that door is pretty much closed, right? So my advice to future ATS plaintiffs, lawyers, consider the safe conduct, because it's really, really big. And second, you might still go after U.S. government contractors that are cozy with the government, but not so cozy to get government contractor defenses available.
Mark, you have 60 seconds for the last word.
Well, I had to defend a case brought against Canada on Tom Lee's safe conduct theory. It wasn't, it didn't, I wouldn't recommend investing money in the safe conduct. I think his historical analysis is powerful, but I think we ought to look into the question, Tom. This is for scholars, not for me. Whether whatever the law was in the 18th century, does that law still apply? I doubt it.
And Mark, I actually came out and I said that in my article. I said, like, look, it would be silly for us to apply that. But if you're an originalist, if you really believe that you should only apply, and Thomas actually seems to come across to say that, and you convince him that the safe conduct could have been any friendly, neutral alien that suffered injury to person or property in the United States, then presumably that should be actionable, right? I disagree with that, but if you're originalist and you follow the theory, then that should be acceptable.
I don't know what the future is, but I do believe that we have to fight to preserve federal common law foreign relations. I believe that John Jay and Alexander Hamilton and the whole bunch of them would roll over, to so to speak, if they knew that we no longer aspire to have to achieve uniform enforcement of the United States obligations under to the World Court or whatever. The area where I think there is potential for litigation, I'm not saying that you're going to get anywhere with this court, is the area of violations of neutrality, tax on Cuba, for example, by people using U.S. territory. And
that might be the subject of a next program, Mark. I think there's so much to say about this, and unfortunately we've run out of time today. So that concludes our excellent program. Thank you so much to our panelists, Tom and Mark, for the terrific and lively conversation. And thank you to all of our attendees. You'll be seeing a link with the recording of the program in the next few days, so be sure to stay tuned for that. If you want to rewatch the panel, and also if you want to watch the May 12th panel that was the prequel, let's say, to this one. Stay tuned for more WFLS events, and have a great night. Bye, everybody.
Thank you, Michael.
Thank you, Michael.
Thank you, Tom. Bye-bye.